penalty imposed, set aside, as vouchers demanded were 10 years old. Rekha got the notice from tax authorities asking her to validate expenditure made on her house construction 10 years ago. Unable to comply with troublesome demand and to avoid the lengthy legal hassles, she decided to pay the taxes. Yet her troubles did not end there. Tax officer levied unwarranted penalty on her. Aggrieved, she appealed to CIT, but in vain, so she finally knocked on the doors of ITAT, who granted her relief. Case leading to penalty under Section 271(1)(c). The case was selected for scrutiny through SAS with remarks of sale of property of Rs 39,31,000. Assessee has declared nil long-term capital gain in his returned income. AO imposed penalty of Rs 1,08,548 under Section 271(1)(c), which is equal to 100% of tax or to be evaded. On appeal, CIT appeal upheld imposition of penalty by AO. On appeal, ITAT held in the case under consideration, although both the lower authorities have alleged that the assessee had presented inaccurate information with the malified intention, the same has not been substantiated convincingly by the department so as to attract penalty. The only finding against the assessee is that she could not produce the relevant vouchers after a lapse of 10 years. Even the Income Tax Act requires maintenance of records for only 8 years. So, it is harsh on the assessee to accept her to produce records for a period falling beyond the statutory prescribed limit. Moreover, the assessee has anyway been taxed on the amount remaining unsubstantiated, and drawing an interference as to the malified intention of the assessee in this regard is a mere presumption. Hence, we are unable to concur with the observations of the Commissioner of Income Tax Appeals and set aside his order and direct that the penalty imposed be deleted. In the result, the appeal of the assessee is allowed.